Have you ever wondered what truly underpins the majestic, sometimes chaotic, yet utterly essential workings of a country's parliament? Beyond the daily debates and the headlines, there's an intricate, meticulously constructed constitutional framework. It dictates everything from who sits in the speaker's chair to how a vote is cast, and even how a member can be removed. This isn't just dry legal text, it's the very bedrock of our democracy.
That's absolutely right. And what's truly fascinating is how these articles, which, might seem purely procedural on the surface, reveal a profound foresight by our constitution makers. They anticipated challenges, ensured continuity, and built in safeguards that are still incredibly relevant today, shaping the integrity and functionality of our legislative process. Today, we're taking a deep dive into several pivotal articles of the Constitution of India, specifically Articles 94 through 106. Think of this as your backstage pass to understanding the fundamental rules of parliamentary governance. We'll unpack the crucial roles of presiding officers, the responsibilities and disqualifications of members, and the essential powers and privileges that allow Parliament to function independently.
And you'll discover the, ingenious mechanisms that prevent legislative paralysis, ensure accountability, and even define the evolving boundaries of parliamentary privilege. We'll highlight some surprising provisions and landmark decisions that have shaped these very rules, giving you a crystal clear understanding of Parliament's inner workings. Our source material today comes from excerpts detailing these constitutional articles, complete with analyses, interpretations, and critical case law. So let's unearth the crucial details and get to the heart of how our Parliament is built to stand strong. Okay, let's kick things off right at the top with the leaders who steer the ship, the Speaker and Deputy Speaker of the Lok Sabha. Article 94 lays out their exit strategy, if you will, how they vacate their office, resign, or can be removed. It's all about ensuring clear, orderly transitions, preventing any leadership vacuum.
Indeed. The Constitution is remarkably meticulous here. It establishes three distinct, well-defined pathways for their demission of office. This structured approach really underpins the stability of the House of the People, ensuring leadership changes are always governed by clear rules, not, political whims.
Right. So the first pathway is, the most straightforward, if they simply cease to be a member of the House. So if a speaker, let's call him Mr. X, loses his election in a general election, his speakership ends automatically. The office is intrinsically linked to his mandate as an elected representative, correct?
Exactly. The moment they lose their seat as an MP, they lose the speakership. It's a direct, automatic consequence. It ensures the presiding officer always maintains the House's mandate through their membership. It's a very logical connection. You represent the people, you preside over their House. When that representation ends, so does the presiding role, immediately. No ambiguity there.
Okay, the second way is voluntary resignation. But here's a detail that often goes unnoticed. Who do they resign to? The Speaker resigns to the Deputy Speaker, and the Deputy Speaker to the Speaker. It's an internal reciprocal chain, isn't it? Keeps the authority within the House.
That's a crucial design choice, yes. This specific addressing of resignation ensures the communication stays within the highest available authority of the House itself. It maintains Parliament's autonomy in its internal affairs and prevents any external intervention in these vital processes. It's a subtle but powerful statement about the internal sovereignty of the legislative branch.
And then the third way. The House itself can actually remove its presiding officers. Now, this sounds like it could be politically charged, but the Constitution makes it quite difficult. It requires a majority of all the then members of the House. What kind of majority is that exactly? Is it just whoever shows up that day?
Not at all. That's a very important distinction. This is what we call an effective majority. It's not just a majority of those present and voting, but more than 50% of the total actual strength of the House at that time, excluding any vacancies. This makes the removal process exceptionally robust. It requires substantial support right across the political spectrum to succeed. It's a high bar to clear, protecting the Speaker from, let's say, whimsical or simple majority decisions based on attendance alone. It really signals the gravity of the decision and the need for broad consensus within the institution.
A high bar indeed. And there's another crucial procedural safeguard. A minimum of 14 days' notice must be given before such a resolution can even be moved. Why the 2-week heads up? Is it simply about giving them time to prepare a defense?
Well, it's partly that, but it's more fundamental. That 14-day notice period is a cornerstone of fairness and due process. It provides ample time for consideration, for the officer concerned to prepare a defense or explanation, yes, but also for debate to mature within the House. It prevents snap decisions or politically motivated removals based on sudden shifts in sentiment. It ensures procedural propriety. It also gives the entire House time to reflect on the implications of such a resolution, making sure it's a considered institutional act, not just a knee-jerk reaction.
Okay, that makes sense. Now, here's something that might surprise people. Even if the Lok Sabha is dissolved, the Speaker doesn't immediately pack their bags. They continue in office until immediately before the first meeting of the House of the People after the dissolution. So what does this continuity mean for the institution? Why keep the Speaker on?
Ugh.
This is a critical provision. It's all about the continuity of the office. It perhaps highlights a deep distrust the Constitution makers had for any potential power vacuum. Even during that interregnum period, between the dissolution of one Lok Sabha and the convening of the next, there is a constitutional head for the House. The Speaker performs crucial administrative duties, oversees the Secretariat, and maintains the institutional memory. They can even, in rare circumstances, preside over a joint sitting of Parliament if one were called during that time. It prevents an institutional vacuum and ensures a smooth transition until the newly constituted House elects its new Speaker. It's a subtle but powerful safeguard against administrative chaos.
So these detailed provisions, they're really designed to ensure that the leadership of our primary legislative body is stable, accountable, and transitions smoothly, even through major political changes. It's about securing the integrity of the institution itself, not just the individuals holding office.
Right, building on that theme of continuity, Article 95 feels like a meticulous contingency plan. It ensures the chair never stays empty. Whether the Speaker is simply absent for a few hours or the office is completely vacant, there's always a protocol in place.
You're right. It's incredibly robust. This article is a testament to the foresight of our Constitution makers in guaranteeing uninterrupted parliamentary proceedings. The objective is clear: prevent any disruption due to the absence or vacancy of the Speaker, ensuring continuous legislative work. So, first scenario. The Speaker's office is actually vacant, say due to resignation or removal. Who steps up? Is it a direct line of succession?
Yes, the Deputy Speaker automatically performs those duties. That's the first port of call. But what if the Deputy Speaker's office is also vacant? That's when the President steps in. The President then appoints a member of the House for this specific temporary purpose. And this brings us to the crucial, albeit conventional, role of the Speaker pro tem.
The Speaker pro tem. We often hear that term right after a general election. What exactly do they do, and why are they so vital? Are they just like a placeholder?
They are far more than a placeholder. They are an essential bridge, really. The Speaker pro tem, usually a senior member chosen for their experience, is appointed by the President after a general election. Their main jobs are to administer oaths to the newly elected members and to preside over the election of the new full-time Speaker. Without them, the new House literally couldn't begin its work or elect its prominent head. They kickstart the new legislative term, fulfilling a ceremonial yet absolutely necessary function.
Okay, so that covers vacancies. What if the Speaker is just absent for a few hours during a sitting? Not a full vacancy, just temporarily unavailable. Is there still a clear protocol, a fail-safe?
Absolutely. The system is designed for that, too. The Deputy Speaker takes the chair. Simple enough. If the Deputy Speaker is also absent, then a person from the panel of chairpersons, determined by the House's rules of procedure, presides. This panel, you see, is nominated by the Speaker at the beginning of each session, usually comprising experienced members from different parties. And in a highly unlikely scenario where none of these are available, Speaker, Deputy Speaker, panel member, the House itself can choose someone for that specific sitting. It's a layered fail-safe, a well-thought-out chain of command, ensuring the wheels of legislative activity never grind to a halt.
So the underlying principle here is truly about avoiding any pause in parliamentary function, no matter how brief. It's a testament to the importance placed on continuous governance.
Exactly. The objective is absolute continuity. And importantly, the powers of anyone acting as Speaker are the same as the Speaker's own powers for that period. No legislative work should ever halt for lack of a presiding officer. This guarantees that debates, voting, and all other parliamentary business can proceed without interruption, maintaining the efficiency and authority of the House.
This article really ensures that the parliamentary clock never stops ticking. Whether it's a temporary break or a major transition, there's always a designated authority to keep the legislative process moving forward. And that upholds order and the rule of law for you, the citizen. Now let's explore Article 96, which is all about fair play and natural justice, particularly when the presiding officers themselves are under scrutiny. If there's a resolution to remove the speaker, they can't be sitting in the chair presiding over that debate, right? That seems like basic fairness.
Precisely. The article explicitly states that neither the Speaker nor the Deputy Speaker shall preside over a sitting when a resolution for their own removal is under consideration. That holds true even if they are present in the House. It's a direct application of that fundamental legal maxim, nemo judex in causa sua. No one should be a judge in their own cause. It's a principle of natural justice embedded right into the parliamentary procedure, ensuring impartiality, or at least the appearance of it.
Okay, so if the speaker is the subject of a removal motion and they can't preside, who does preside then? Do they just pick someone randomly?
Not quite. It follows the logic we just discussed. In such cases, the provisions of Article 95(2), the rules for a speaker's temporary absence, kick in, so the deputy speaker would normally preside. Or, if they are unavailable, or perhaps the subject of the motion too, then a member from the panel of chairpersons would take the chair. This ensures that the proceedings are conducted by an unbiased party, lending legitimacy to such a critical process.
Makes sense. But the speaker or deputy speaker facing removal, they can still speak and participate, can't they? To defend themselves. They aren't just removed from the room, are they?
Absolutely not. That would violate natural justice, too. They retain their right to speak and participate as a regular member of the House. They can present their case, offer explanations, and try to persuade other members. And crucially, they are entitled to vote only in the first instance on such a resolution.
Only in the first instance. That phrase sounds significant again. What's the implication there? Why not a casting vote if there's a tie?
This is a very important clarification. Normally, as we'll discuss under Article 100, the presiding officer has a casting vote to break a tie. It's a power they exercise to resolve deadlocks. But in their own removal proceedings, they explicitly do not have that casting vote. This prevents them from using that unique power to save themselves from removal. Imagine the votes are equal. If the speaker had a casting vote, they could effectively vote to keep their job. This provision removes that possibility entirely, ensuring the outcome is determined solely by the majority will of the House, without any procedural advantage for the person under scrutiny. It cements impartiality.
This article is a brilliant example, really, of how our Constitution embeds principles of natural justice right into the heart of parliamentary procedure, even when it comes to its highest offices. It protects fairness and ensures accountability, making sure the process itself is beyond reproach. With the roles and rules clearer, let's talk about how the Constitution ensures these key figures can actually do their jobs without financial pressure. That brings us to Article 97, covering salaries and allowances. This article covers the Speaker and Deputy Speaker of the Lok Sabha and also the Chairman and Deputy Chairman of the Rajya Sabha. So it's about compensating the top legislative roles in both houses.
That's right. Their emoluments are fixed by Parliament by law. Until Parliament made such a law, they were guided by the second schedule of the Constitution. This means Parliament itself decides their pay. It's a mechanism for parliamentary self-governance in a practical sense. The idea is to ensure their dignity and enable them to focus on their duties without external financial pressures or dependencies.
And here's where we find a subtle, but I think profound safeguard. These salaries and allowances are charged on the Consolidated Fund of India. What's the big deal about being charged? Why is that so important for their independence?
This is absolutely fundamental to their financial independence. It's a really surprising and crucial safeguard. Being charged means these expenditures are not subject to the annual vote of Parliament during the budget process. They are automatically paid out of the nation's treasury. This prevents the government of the day, the executive, from using financial leverage against the presiding officers. Their salaries can't be cut or debated during budget discussions as a political tool. It effectively insulates them from political pressures and ensures they are not beholden to the government for their remuneration, which is absolutely critical for their impartiality.
So think of it as insulating these critical figures from political arm twisting. By ensuring their financial security is non-negotiable, the Constitution helps them remain impartial arbiters of parliamentary proceedings. And that's a cornerstone of fair governance for the nation, isn't it? Next up, let's dive into Article 98, which establishes the Secretariat of Parliament. These are truly the unsung heroes behind the scenes, ensuring the smooth functioning of Parliament day to day. Each house gets its own secretarial staff. Why is it so important that they are separate from, say, the executive branch's civil service staff?
This is absolutely vital for maintaining the independence of the legislature. Just imagine if Parliament's administrative support, its staff, were controlled by the executive branch. It could seriously compromise its ability to function effectively and, critically, hold the government accountable. how could it scrutinize freely if its own staff reported elsewhere? These secretariats are under the administrative control of the Speaker for Lok Sabha and the Chairman for Rajya Sabha. This ensures they serve the House, not the government. This administrative separation of powers is arguably as important as the functional separation, preventing any subtle influence or even obstruction.
But the article does allow for common posts between the two houses, right? For efficiency, perhaps.
Yes, the proviso is pragmatic. It allows for efficiency where certain functions can be shared, things like library services, research and reference, or even security. Sharing these can save resources without undermining the overall independence of each house's core legislative functions. These common services support both houses while still ultimately reporting to the respective presiding officers. It's a smart way to manage resources without compromising that core principle of legislative autonomy.
Okay, so who sets the rules for hiring and employment for these crucial staff members? Does the government just impose its own civil service rules on them?
Not at all. Parliament itself has the power to legislate on these matters, recruitment, conditions of service, etc. Until such laws are made, the president can make rules, but crucially, after consulting with the speaker or chairman, as the case may be. This again underlines the principle that Parliament's internal administration is distinct from the general civil service and directly tied to the legislative branch's leadership. It ensures the staff are recruited and managed according to the unique needs and standards of the legislative branch, not necessarily the executive's rules or priorities.
So the whole point is to ensure Parliament can operate without outside interference, truly embodying the administrative separation of powers.
Precisely. These secretariats handle everything from legislative support, drafting help, research and committee work, to reporting debates accurately, managing parliamentary papers, and so much more. They ensure that the legislative body has its dedicated, unbiased support system to scrutinize, debate, and legislate effectively. They are the institutional memory and the administrative engine of Parliament. Without such independent and dedicated staff, the sheer volume and complexity of legislative work would be unmanageable or worse, susceptible to external influence. And that would ultimately impact the quality of legislation and oversight that affects all of us.
This might sound like a technical detail, but it's really a foundational piece of our democratic puzzle. An independent parliamentary secretariat ensures that your elected representatives receive unbiased support. It allows them to focus on legislation and oversight without executive influence. It's literally how the work gets done, free from external meddling. Now, let's shift focus from the institution structure to the members themselves. Article 99, this is about the solemn promise they make. Before taking their seat, every member of either House Lok Sabha or Rajya Sabha must take an oath or affirmation. It's not optional, is it? It's a fundamental prerequisite.
Absolutely fundamental. And that phrase, before taking a seat, is crucial in its timing. It means they cannot participate in debates, they cannot vote, they can't even draw a salary as a member until this solemn undertaking is complete. It effectively legitimizes their participation, making their entry into legislative functions contingent upon this public pledge. It's a constitutional gatekeeping mechanism.
Who actually administers this oath? Is it always the president?
Yeah. It's administered by the president or by someone appointed by the president for that purpose. For new Lok Sabha members after an election, this duty typically falls to the Speaker pro tem, that temporary speaker we discussed earlier, who's appointed specifically for this and overseeing the speaker's election. For Rajya Sabha members who are elected at different times, it's usually the chairman, who's the vice president of India, or, again, a person appointed by the president. This ensures the constitutional sanctity and seriousness of the oath-taking process.
And what exactly are they swearing to? What's in the oath itself? Is it just a formality?
Oh, it's far from just a formality. The form is explicitly set out in the third schedule of the Constitution. It's not left to chance. It's a pledge of true faith and allegiance to the Constitution of India, a promise to uphold the sovereignty and integrity of India, and a commitment to faithfully discharge the duties of their office. It's a direct constitutional commitment to the nation's foundational document and its core values, placing the Constitution above all other loyalties. It's not merely a ritual, but a binding legal and ethical promise they make.
So this isn't just a formality. It's the very first promise your representative makes upon entering Parliament. It's their constitutional contract with the nation and with you to uphold the nation's foundational values and serve your interests within that framework. It sets the stage for their entire tenure. Okay, now let's get into the nuts and bolts of decision-making in Parliament with Article 100. This covers voting, quorum, and validity of proceedings. So how are decisions generally made? Is it always just a simple majority of those present and voting?
That's the general rule, yes. Majority of votes of the members present and voting. It's the standard principle of democratic decision-making. It ensures that the will of the actively participating majority prevails on most matters. However, there's that critical nuance for the presiding officer, the speaker, or chairman.
Right, and that nuance is they don't vote in the first instance, do they? They typically stay neutral during the vote count.
Correct. They usually don't vote initially. This is crucial to maintain their impartiality and neutral stance during debates and voting. Their unique power is the casting vote, which they only exercise in the specific situation of a tie and equality of votes. This power helps break deadlocks and allows the House to proceed with its business while preserving the perception of their neutrality, which is vital for the smooth conduct of parliamentary affairs. So if a motion ties 200-200, the Speaker would then cast their vote to resolve it one way or the other.
What happens if some seats in the House are vacant? Or maybe it's discovered later that someone voted who wasn't actually qualified or had been disqualified. Does that invalidate everything the Parliament has done? That sounds potentially chaotic.
This is a vital safeguard provided by Article 100, Clause 2. It's crucial for the stability of parliamentary decisions. The article explicitly states that Parliament has the power to act despite any vacancy in its membership. And, importantly, its proceedings remain valid even if it's discovered later that an unqualified or disqualified person sat, voted, or otherwise participated. This prevents the retrospective invalidation of laws or decisions on purely technical grounds. Imagine the chaos if laws passed years ago could be struck down because one MP was later found to be disqualified. This ensures continuity and certainty in governance.
Okay, that's reassuring. Now, what's the minimum number of members needed for Parliament to actually conduct business? We call that the quorum, right?
Yes, the quorum. It's covered in clauses 3 and 4. Until Parliament legislates otherwise, the Constitution sets the quorum at 1/10 of the total number of members of the House. So, for the Lok Sabha, with its current strength of 543 members, that's 55 members, including the presiding officer, this ensures that decisions aren't made by just a tiny fraction of the House, maintaining a reasonable level of representation and preventing hasty decisions in an almost empty chamber. It lends legitimacy to the proceedings.
And if that quorum isn't met, if attendance dips below 1/10, does everything just stop?
Precisely. It's the constitutional duty of the presiding officer, the speaker, or chairman to act. They must either adjourn the House or suspend the meeting until the quorum is met. No business can be transacted without it. If a member raises a quorum call by pointing out the lack of quorum and after ringing the bells the required number isn't present, the House must stop its proceedings. It's a non-negotiable threshold.
These rules really form the engine room of parliamentary democracy, don't they? They ensure that decisions are made by legitimate majorities, that proceedings aren't easily derailed by technicalities like vacancies, and that a minimum number of your representatives are present to truly reflect the will of the House. Article 101 addresses when a seat becomes empty. It lays out the specific grounds for the vacation of seats. It outlines these crucial provisions governing a member of Parliament's tenure, setting the rules for how and why someone might stop being your representative. For example, you can't be a member of both houses of Parliament or both Parliament and a state legislature at the same time, right? That's a clear prohibition.
That's absolutely correct. Clauses 1 and 2 of Article 101 ensure this principle of single representation. If a person happens to be chosen for both Lok Sabha and Rajya Sabha, Parliament has made laws, specifically the Representation of the People Act, 1951, stipulating they must choose which seat to retain within a specified time, usually 10 days. If they don't choose, their Rajya Sabha seat typically becomes vacant. Similarly, if an individual is elected to both Parliament and a state legislature, rules made by the President under this article say their parliamentary seat becomes vacant after 14 days unless they first resign their state legislative seat.
Why this strict separation? It seems quite absolute, preventing any overlap.
It's fundamentally about ensuring full dedication to one legislative body. It prevents potential conflicts of interest or divided loyalties. It ensures that our representative can focus solely on their given mandate, whether it's at the national level in Parliament or at the state level, providing better, more focused representation for their constituents without their attention and responsibilities being split.
Okay, that makes sense. Now, if a member becomes disqualified under the rules we'll discuss next, Article 102, their seat automatically becomes vacant. That's clear. But what about resignation? Can an MP simply resign whenever they want, or are there safeguards?
A member can resign, yes, by writing to the Speaker or Chairman as appropriate. The seat becomes vacant upon acceptance of the resignation. However, there's a crucial safeguard that was added by the 33rd Amendment Act back in 1974. This proviso gives the Speaker or Chairman the power, in fact, the duty to inquire if the resignation is truly voluntary and genuine. If they have information or believe it's not voluntary or genuine, they do not have to accept it.
That's a significant check on the resignation process. What was the context? Why was that proviso added? Was there a specific problem it was designed to solve?
It was a direct response to concerns prevalent at the time about coerced resignations. There were instances or allegations where members might have been pressured by their parties or other external forces to step down against their will, perhaps to engineer by-elections or change political equations. This gives the presiding officer a quasi-judicial power to protect the autonomy and free will of the member. And by extension, it protects the integrity of the House and its representative character. It's a powerful tool against political manipulation, ensuring a member's choice to resign is truly their own.
Very interesting. And what if an MP just disappears for a long time? If they're consistently absent without leave, is there a constitutional consequence for that?
Yes, Clause 4 deals with this. If a member is absent from all meetings of the House for a continuous period of 60 days without the permission of the House may declare their seat vacant. Note the word may. It's discretionary for the House, not automatic. The House has to pass a motion to this effect. Importantly, any period during which the House is prorogued or adjourned for more than 4 consecutive days is excluded from the calculation of those 60 days. This ensures fairness, so members aren't penalized for periods when the House isn't genuinely meeting for extended stretches.
So these provisions in Article 101 really clarify when and how a seat in Parliament can become empty. They prevent individuals from holding multiple, conflicting positions, protect members from forced resignations, and address prolonged absences. It's all about ensuring your representatives are truly committed, present, and accountable. Okay, let's move to Article 102. This defines who can serve by laying down specific disqualifications for membership. It's about maintaining the integrity, independence, and, well, suitability of our legislative body members. The office of profit rule is a big one, often causing controversy. What exactly does it mean to hold an office of profit under the government, and why is it a disqualification?
Right. This is probably the most litigated ground. It's designed fundamentally to prevent legislators from holding positions under the executive government that could create a conflict of interest or allow the executive to exert undue influence over them through patronage or financial dependence. The idea is that an MP's primary allegiance should be to their constituents and legislative duties, not to a government-controlled position that might offer financial gain or other benefits. Now, office of profit isn't explicitly defined in the Constitution itself, so courts have laid down tests looking at factors like who appoints the person, who can remove them, is there remuneration attached, what degree of control does the government exercise over the office. However, Parliament itself has the power, through legislation, to declare that holding certain specific offices will not disqualify a member. This allows for practical adjustments. And notably, the Constitution clarifies that being a union or state minister is not considered holding an office of profit for this purpose. That's a practical necessity for the parliamentary system of governance to function.
And wasn't there a landmark Supreme Court case, Jaya Box versus Union of India, that really shaped our understanding of this office of profit rule?
Yes, absolutely. In 2006, the Supreme Court delivered a significant judgment in that case. The court clarified that the crucial factor is whether the office is capable of yielding profit or pecuniary gain. The actual receipt of profit isn't necessary. If the office carries the potential for profit, that's enough for disqualification. This broadened the scope significantly and tightened the integrity requirement. It ensures the spirit of the law preventing potential conflicts is upheld, not just the technicality of whether money actually changed hands.
Okay, besides office of profit, what are some of the other explicit grounds for disqualification laid out in Article 102, Clause 1?
Well, there are several straightforward ones. Being of unsound mind, provided it's declared by a competent court. Being an undischarged insolvent, essentially, someone who is bankrupt and hasn't settled their debts. And then there are grounds related to citizenship. If the person is not a citizen of India, or has voluntarily acquired the citizenship of a foreign state, or is under any acknowledgement of allegiance or adherence to a foreign state, these are pretty fundamental, ensuring mental capacity, financial responsibility, and undivided national allegiance, all seen as critical attributes for a lawmaker representing Indian citizens.
And Clause 1 mentions another category of disqualification under any law made by Parliament. This gives Parliament flexibility to add more grounds, I imagine.
Exactly. This allows Parliament to adapt the disqualification framework to evolving needs and circumstances. The primary law made under this provision is the Representation of the People Act, 1951, RPA. The RPA lays down several additional disqualifications, including conviction for certain criminal offenses, especially those resulting in imprisonment for 2 years or more, engaging in corrupt electoral practices, failing to lodge election expenses, or having an interest in government contracts.
And didn't the Supreme Court case, Lily Thomas versus Union of India, dramatically change how criminal convictions affect sitting MPs under the RPA? I recall it being quite a significant ruling.
It was indeed a landmark ruling in 2013. Before that, Section 8.4 of the RPA allowed convicted MPs and MLAs a 3-month window to appeal, and they wouldn't be disqualified until the appeal was finally decided, which could take years. The Supreme Court struck down this Section 8.4 as unconstitutional. The court held that disqualification upon conviction for specified offenses, generally those leading to 2 or more years imprisonment, is automatic and immediate. This made the system much more stringent in ensuring that convicted criminals are removed from legislative bodies without the protection of lengthy appeals. It was a major step aimed at cleaning up politics.
Right. And then there's Clause 2 of Article 102, which brings in disqualification on the ground of defection, introduced later by the 52nd Amendment. This is the anti-defection law, often in the headlines.
Correct. This clause states that a person shall be disqualified if they are disqualified under the 10th Schedule of the Constitution. The 10th Schedule lays down the rules for anti-defection. Broadly, a member can be disqualified if they voluntarily give up membership of the political party on whose ticket they were elected, or if they vote or abstain from voting in the House, contrary to any direction or whip issued by their political party, without obtaining prior permission or having the act condoned by the party within 15 days. This was introduced in 1985 to curb political horse trading and promote stability by discouraging elected representatives from switching parties frequently, often for personal gain or political convenience, which often destabilized governments.
But the decision on defection rests with the Speaker or Chairman, doesn't it? And is there an element of judicial review involved, despite the schedule initially saying the Speaker's decision is final? I remember the Quijano-Holohan case being important here.
You're spot on. The 10th Schedule originally tried to exclude judicial review completely. However, in the landmark Quijano-Holohan versus Zakilu case in 1992, often cited as 1993, the Supreme Court upheld the validity of the 10th Schedule but struck down the provision barring judicial review. The court held that the Speaker or Chairman functions as a tribunal while deciding defection cases, and their decision, while initially final regarding parliamentary proceedings, is subject to judicial review. However, the review is on limited grounds such as malefides, acting in bad faith, bias, violation of natural justice, perversity, a decision no reasonable person could reach, or non-compliance with constitutional provisions. This maintains a crucial balance between ensuring parliamentary discipline and preventing the Speaker's power from being absolute or politically misused, allowing the courts to intervene if the process is fundamentally flawed.
So these disqualifications, taken together, are really fundamental to maintaining a legislature that meets certain ethical, legal, and loyalty standards. They define the baseline requirements your representatives must meet, ensuring they serve the nation, not personal gain, conflicting interests, or foreign allegiances. With so many potential grounds for disqualification under Article 102.1, the question naturally arises: who actually decides if a sitting member has become disqualified after their election? Article 103 deals with this specific scenario, decisions on questions as to disqualifications of members. If a question arises about an MP's disqualification, say they're accused of holding an office of profit after being elected, who makes the final call? Is it the courts?
No, interestingly, it's not the courts in the first instance for these post-election disqualifications under Article 102.1. The question, according to Article 103, is referred to the President of India, and the article explicitly states that the President's decision on the matter shall be final. It's crucial, though, to remember the scope here. This applies only to disqualifications incurred after being elected and only under the grounds listed in Article 102, Clause 1, like office of profit, unsound mind, insolvency, citizenship issues, or RPA violations arising post-election. It does not cover pre-election disqualifications. Those are challenged through election petitions in the high courts. And very importantly, it does not cover disqualifications under the 10th Schedule for defection. As we just discussed, defection cases are decided by the Speaker or Chairman. This clear demarcation avoids jurisdictional confusion.
Okay, so the President decides. But the President doesn't act alone on this, based purely on political advice, right? There's a mandatory consultation mentioned that seems quite powerful.
Absolutely critical point. Before giving any decision on such a question of disqualification, the president must obtain the opinion of the Election Commission of India. And here's the real kicker, the binding part. The president shall act according to such opinion.
So the Election Commission's opinion is, in effect, binding on the president. That's an incredible power vested in an independent constitutional body, especially concerning the fate of an elected legislator.
It is effectively binding, yes. This wasn't always the case. The 42nd Amendment during the emergency had made the president's own satisfaction supreme, but the 44th Amendment wisely restored the original position, making the Election Commission's opinion binding. This provision ensures that a technical and politically sensitive matter like disqualification is decided based on the expert, impartial, and considered advice of the independent constitutional body responsible for electoral integrity. It prevents it from becoming a purely political decision by the executive. It removes the potential for executive influence or political maneuvering in these specific disqualification matters, thereby upholding neutrality and fairness in a potentially contentious area.
So when the Election Commission gives its opinion, is it just stating a view, or does it function more like a court in this situation? Does it hold hearings?
It essentially acts in a quasi-judicial capacity when dealing with these references under Article 103. It's expected to follow principles of natural justice. This means conducting inquiries, examining evidence, and importantly, hearing the concerned member and any other relevant parties before tendering its binding opinion to the president. This ensures a fair process, giving due opportunity to the member whose qualification is being questioned before a final, potentially career-ending decision is made by the president based on that opinion.
This article really creates an essential check and balance, doesn't it? It ensures that decisions about removing a sitting MP on these specific grounds are made impartially by an expert body insulated from political winds, rather than becoming a tool for political vendetta. It protects the integrity of your representation. And what happens if someone ignores all these rules? If they sit and vote in Parliament when they shouldn't? Article 104 outlines the penalty for this kind of improper participation. So if someone sits or votes in Parliament without taking the Article 99 oath, or knowing they're not qualified, or maybe after being disqualified, there's a specific penalty for that.
Precisely. Article 104 acts as a clear deterrent against unauthorized participation in parliamentary proceedings. The penalty applies if a person sits or votes as a member under 3 specific conditions. 1, before they have taken the oath or affirmation required by Article 99. 2, when they know they are not qualified or that they are disqualified from membership. Or 3, when they know they are prohibited from doing so by any law made by Parliament. It's a strict liability provision for knowingly participating when not entitled to.
What's a financial hit for such an infraction? Is it just a token fine, or does it have teeth?
Well, the amount specified is 500 rupees for each day the person improperly sits or votes. And this amount is recoverable as a debt due to the union government. Now, while Rs 500 might seem somewhat modest by today's standards, remember this was set by the constitution makers decades ago. More importantly, it's the principle. It's a symbolic constitutional slap on the wrist, a clear statement that such unauthorized participation carries a tangible financial consequence and constitutes a serious breach of constitutional requirements. And of course, prolonged violations can lead to significant cumulative penalties, underscoring the seriousness of the breach. If someone knowingly sat and voted for, say, 30 days while disqualified, they would owe 15,000 rupees, not insignificant.
So its primary purpose is really as a deterrent, to protect the sanctity and legitimacy of parliamentary proceedings. A constitutional gatekeeper with a small but persistent fine.
Absolutely. Its existence reinforces the strict compliance required with all the constitutional prerequisites for parliamentary participation, the oath, the qualifications, the absence of disqualifications. It serves to ensure that only those legitimately entitled to represent the people and make laws can actually participate in shaping the nation's laws. It safeguards the integrity of the entire legislative process from unauthorized influence or participation.
This provision really underpins the legitimacy of every vote cast and every debate held in Parliament. It ensures that only properly qualified, sworn-in representatives are making decisions on your behalf, safeguarding the very integrity of the legislative process itself. We're now moving into our final section, Section 3, focusing on parliamentary powers, privileges, and member emoluments. Let's kick off with Article 105. This article is fundamental. It's about shielding the legislature, granting Parliament, its members, and committees specific powers, privileges, and immunities. These are considered essential for their independent and fearless functioning, free from external interference. The first privilege mentioned, right in Clause 1, is freedom of speech within Parliament. Why is this specific parliamentary freedom of speech so crucial? Isn't free speech a general right anyway?
It is, but parliamentary freedom of speech is distinct and, arguably, stronger in its context. It's considered a cornerstone of parliamentary democracy worldwide. It allows members to speak frankly, critically, debate vigorously, and question the government without fear of legal reprisal like defamation suits or other civil or criminal action for what they say inside the House or its committees. This ensures robust debate and empowers them to hold the executive accountable effectively. However, this freedom isn't absolute within the House. It is subject to other provisions of the Constitution, like restrictions related to decency, defamation, etc., though court action is barred, and importantly, to the rules of procedure and conduct of business of the House itself. These rules ensure that debate remains orderly, relevant, and doesn't cross certain lines, like making defamatory statements against high dignitaries or discussing the conduct of judges except on a specific removal motion. It's about creating a protected space for fearless debate, not unchecked license.
And here's where it gets really interesting in Clause 2. Members have absolute immunity from court proceedings for anything they say or any vote they cast in Parliament or its committees. So just to be clear, you absolutely cannot sue an MP for defamation for something they said during a parliamentary debate, right?
Exactly. That immunity from any proceedings in any court in respect of anything said or any vote given by a member in Parliament or any committee thereof is absolute and vital. It protects legislators from external pressure, harassment through litigation, or intimidation, allowing them to perform their duties without fear or favor. Imagine if every critical speech could lead to a lawsuit. It would completely stifle debate. The same absolute immunity extends to the publication, by or under the authority of either House of Parliament, of any report, paper, votes, or proceedings. This protects official parliamentary records.
But there's been a significant, very recent development regarding this immunity in the issue of bribery, hasn't there? This has been quite controversial over the years. I recall the P.V. Narasimha Rao case, often called the JMM bribery case, back in the 90s, and then something very new happened just this year, overturning that precedent.
You're absolutely spot on. This is a crucial evolution. In the 1998 P.V. Narasimha Rao case, the Supreme Court, by a narrow 3-2 majority, delivered a controversial judgment. It held that MPs who allegedly took bribes to vote or speak in a certain way in Parliament were indeed immune from criminal prosecution for the act of voting or speaking itself, thanks to Article 105(2). Although the judgment suggested they could still be prosecuted for the separate act of taking the bribe under anti-corruption laws, the immunity for the core legislative act performed under the influence of the bribe was upheld. This was widely criticized as creating a loophole for corrupt legislators.
That sounds like a huge gap in accountability. So what does this all mean for us now, especially after the recent Supreme Court decision? Has that loophole been closed?
It absolutely has. Just this year, in February 2024, a larger 7-judge bench of the Supreme Court delivered a unanimous verdict in the Sita Soren versus Union India case. They explicitly overruled the majority view in the P.V. Narasimha Rao judgment. The court declared unequivocally that parliamentary privilege under Article 105(2) does not grant immunity from prosecution for bribery in connection with a vote cast or speech made in the legislature. This is a monumental shift, a huge aha moment, because it completely redefines the boundary between legitimate privilege and criminal conduct. It states clearly that bribery is not essential to legislative function and therefore cannot be protected under the guise of parliamentary privilege. It reinforces the principle that privilege exists to safeguard the integrity of legislative functions, not to shield criminal acts. This significantly strengthens accountability.
Okay, that's a massive clarification. And now beyond freedom of speech and voting, what are these other privileges mentioned in Clause 3 that Parliament and its members enjoy? The Constitution doesn't actually list them all out, does it?
You're right, they are largely uncodified. Clause 3 originally stated that other privileges would be those of the UK House of Commons at the commencement of our Constitution, until defined by Parliament, by law. Parliament hasn't passed a comprehensive law codifying all these privileges yet, so effectively they remain largely based on the historical privileges of the House of Commons. These include several crucial powers and immunities. For instance, freedom from arrest in civil cases during the continuance of a session of the House, and for a period of 40 days before its commencement and 40 days after its conclusion. Note, this doesn't apply to criminal cases or preventive detention. Other key privileges include the right of the House to regulate its own internal proceedings, the right to exclude strangers from its galleries, and importantly, the power to punish its own members and even outsiders for breach of privilege or contempt of the House.
So Parliament can effectively act as its own court for contempt. It can punish people for disrespecting it. That's a serious power.
It is indeed a significant power, often described as quasi-judicial. This inherent power is considered vital for protecting the dignity, authority, and smooth functioning of the House. We saw this power asserted and judicially examined in the Cash for Query case, Raja Rampal versus Honorable Speaker Lok Sabha, 2007. In that case, the Supreme Court upheld Parliament's power to expel its own members for gross misconduct amounting to contempt, finding it inherent in parliamentary privilege. However, the court also affirmed that while Parliament has this power, its exercise is subject to limited judicial review, specifically on grounds of illegality, constitutional infirmity, or perhaps gross irrationality, ensuring some check on this power.
And these privileges, do they extend only to MPs? What about non-members who have a right to speak in the House, like ministers who might be members of the other House or the Attorney General?
Yes, Clause 4 of Article 105 explicitly extends these powers, privileges, and immunities to those persons who, by virtue of the Constitution, have the right to speak in and otherwise take part in the proceedings of either House or any committee thereof. This clearly covers ministers who can speak in the House they aren't a member of, as per Article 88, and the Attorney General of India, who also has the right of audience under Article 88. This ensures they can fulfill their roles in parliamentary proceedings without fear of legal repercussions for their official statements made within the legislative chamber.
So these privileges are a vital shield, allowing your representatives and key officials like ministers to perform their duties without fear or favor. But that recent Supreme Court ruling on bribery immunity is a huge aha moment, isn't it? It clarifies definitively that this shield is not a license for corruption, reinforcing the ethical standards we should expect from those who legislate on your behalf. It truly shows our Constitution is a living document, adapting to uphold integrity. Alas. Finally, we arrive at Article 106, which deals with the more practical matter of salaries and allowances for members. It seems straightforward. All members of Parliament are entitled to receive salaries and allowances. And again, like the presiding officer's pay, Parliament itself determines these amounts by law, right?
That's correct. Article 106 empowers Parliament to determine, by law, the salaries and allowances of members of both the Lok Sabha and the Rajya Sabha. It's Parliament's prerogative to set the emoluments for its own members. This is intended to ensure their financial independence, allowing them to dedicate themselves to public service without undue financial hardship. It also aims to enable individuals from diverse economic backgrounds, not just the wealthy, to serve as representatives. Initially, until Parliament enacted specific legislation, the article provided that members would receive allowances based on what constituent assembly members received. But soon after, Parliament passed laws like the Salary, Allowances, and Pension of Members of Parliament Act, 1954, which has been amended periodically to revise these emoluments.
Now, Parliament deciding its own pay often sparks considerable public debate, doesn't it? It's frequently a point of contention and sometimes criticism in many democracies.
It absolutely does, and it's a perfectly valid point of public discussion in any democracy. There's an inherent potential conflict of interest when any group sets its own compensation. The constitutional intent behind Article 106 is sound: to provide adequate remuneration so members can discharge their duties effectively, maintain the dignity associated with their office, and importantly, not be vulnerable to undue influence or corruption due to financial hardship. However, achieving the right balance between ensuring fair compensation for demanding public service, maintaining parliamentary independence, and ensuring public accountability and transparency is a delicate act. It's a tension that is constantly negotiated in the public sphere. The objective is to attract capable individuals to public service and enable them to perform their duties without financial distractions or susceptibility to corruption. But the public also rightly expects justification and restraint, especially when economic times are tough for ordinary citizens.
So, ensuring your representatives are adequately compensated is important for attracting capable individuals to public service and reducing potential vulnerabilities to undue influence. It's fundamentally about enabling them to devote themselves fully to their demanding work for the nation. Though the process of Parliament setting its own pay itself remains, quite understandably, a constant subject of public interest and debate.
Well,
Wow, what a deep dive that was. From the meticulous rules governing the Speaker's office and the vital, often unseen work of the Parliamentary Secretariat, to the stringent requirements for a member's oath, voting procedures, the crucial quorum, and the various grounds for disqualification. And finally, delving into the essential powers and privileges that define Parliament's independence and operational freedom, we've really covered a remarkable span of constitutional wisdom packed into these articles.
They really aren't just dry legal articles, are they? When you unpack them, you see they are the very scaffolding that upholds India's democratic process in Parliament. They ensure continuity, accountability, and fairness. They provide mechanisms to prevent paralysis, curb unethical behavior like defection or corruption, and empower the legislative branch to function effectively and hopefully fearlessly. The clarity we discussed, for instance, on the binding nature of the Election Commission's opinion in disqualification cases under Article 103, and especially that recent, powerful overturning of bribery immunity under Article 105, these highlight a living, evolving constitution. It's constantly being interpreted and refined to meet contemporary needs for integrity and public trust.
In every why and how we explored today, from the Speaker's casting vote to the anti-defection rules, from the Office of Profit to freedom of speech, directly impacts the quality of governance and representation you, the listener, receive. Understanding these foundational rules gives you a deeper appreciation for the intricate safeguards built into our system. It makes you a more informed citizen, capable of engaging more meaningfully with the processes and institutions that shape our nation. It's about seeing the hidden gears turning in the machinery of democracy.
And as we consider these foundational rules and their sometimes surprising evolution, it makes you think, doesn't it? What might be the next step, the next challenge or refinement in parliamentary integrity and accountability that a future amendment or another landmark ruling could bring? How do we, as a society and through our institutions, continue to balance that crucial, undeniable need for strong, independent legislative bodies capable of holding power to account with the ever-increasing public calls for transparency, ethical conduct, and direct scrutiny, especially as our democracy matures in a complex, globally connected world? That balance is always dynamic.
We certainly hope this deep dive has given you a fresh perspective on the constitutional bedrock of our Parliament, going beyond the daily headlines. Keep digging, keep questioning the structures that govern us, and stay well informed.